Mr. Maupin is here now, along with his attorney, Mr. Patrick Allen. The people are here and represented by their elected prosecutor, Mr. Scott Kerner. Agent Twilliger is present from the Michigan Department of Corrections. Let's inquire first. I know we got that PRV issued, and Mr. Twilliger had a research assignment. Were you able to discern whether or not that conviction was a misdemeanor or a felony?
Yeah, so the original charge was a misdemeanor operating with a high BAC, which was enhanced to a felony operating while intoxicated, impaired third offense, which he pled guilty to.
A felony then?
Yes.
Is that sorted then?
Yeah, I would, that's what my client explained to me as well, too.
Very good then. Mr. Maupin, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. You may put your hand down. Mr. Maupin was before the court last on January 22nd of the year 2026. And on that date, he pled guilty to operating while intoxicated, third offense, habitual offender, second. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report distributed to the parties and to the court. We would have been here for a sentence date on February 27th of the year 2026, but Mr. Maupin was FTA or failed to appear. So we do, at first instance, need to change the sentence date to reflect today's date of March 24th, 2026, which will invariably change our credit.
Missing your sentencing date is one of the worst moves you can make in court. That single failure to appear instantly changed the tone of this entire hearing.
Date, I'm sure between Mr. Allen and Mr. Twilliger, we'll get that figured out. So I have the pre-sentence investigation report prepared by the Michigan Department of Corrections, along with a sentencing information report. There was an addendum to the pre-sentence investigation report to account for some court action that occurred in Genesee County between the date of the plea and today. I believe that the attorneys have received that and were able to review that. Is that correct, Mr. Allen?
It is.
Mr. Kerner?
Yes, Your Honor.
All right. With that, then, Mr. Maupin, would you raise your right hand? Do you promise that you will tell the truth, the whole truth, nothing but the truth? So help you God.
I do, Your Honor.
Thank you. You may put your hand down. Mr. Maupin, did you get a chance to review the pre-sentence investigation report?
I did, Your Honor.
And your attorney, Mr. Allen, did he make himself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
He did, Your Honor.
All right. And as you read through that report, Mr. Maupin, did you find everything in it truthful and accurate?
Yes, Your Honor.
Thank you. Mr. Allen, have you had a chance to review the pre-sentence investigation report?
We have.
Any changes you'd like to see made to the body of that document, Mr. Allen?
To echo, in terms of days credit, we had an additional 57 for a total 126 days.
126. Mr. Kerner, Mr. Twilliger?
No objection.
I'm unaware of the time he spent. I was under the impression he was picked up for a probation violation in Genesee County. I'm not sure if that would count towards his credit on this matter.
Mr. Allen?
I think that when my client didn't show up for sentence, his bond was revoked, and then he was picked up over in Genesee County, I think the day after, as it's indicated, and has been in jail in Genesee County since February 27th, 2026.
The court did issue the bench warrant the day he FTA'd. Does that change your analysis, Mr.
Okay,
Twilliger?
I just wanted to make sure that was, so though you said 126 was the total?
Correct.
Mr. Kerner?
Stipulated.
126 it is then, Mr. Allen. Anything else?
Just merely, it's a typo, I believe, on the addendum report. It's in the second, I guess it'd be the first sentence of the third paragraph, receiving an OUL on 8/10. That should be not 22, 8/10/25.
Yep, I think we acknowledge that, Mr. Twilliger. He was under the gun to get that done, so.
I did actually find another spelling or a mistake, I should say.
Send it.
Last paragraph said the hearing was held in Genesee County 7th District Court. That should say 7th Circuit Court.
Mr. Allen?
That's correct.
Okay. Anything else, Mr. Allen?
Other than that, we have no additions, deletions, or corrections.
Let's move over to the people then. Mr. Kerner, have you had a chance to review the pre-sentence investigation report?
Yes, Your Honor.
Any changes you'd like to see made to the body of that report?
None to the body.
Let's stay with the people then and see if there are any challenges to the sentencing information report. Mr. Kerner.
Yes, PRV 7 should be 10 points based upon the addendum indicating he pled guilty to a felony, subsequent felony.
Yes, that was the issue. Mr. Allen?
I would agree.
Pardon me?
I would agree.
Mr. Twilliger, give us 10 points on PRV 7, please.
Yes, Your Honor.
Mr. Kerner.
And OV-19 should be 10 points.
For the FTA in February, correct?
Correct.
Mr. Allen.
As much as I want to argue against that, there's case law right on point.
It is. You are exactly correct. 10 points then, Mr. Twilliger, on OV-19. Any other challenges, Mr. Kerner?
No, Your Honor.
Mr. Allen, for the defense, do you have any scoring challenges to the SAR?
No, thank you.
Mr. Twilliger, add them up.
The new total PRV will be 72, which stays at a level E. The new OV level will be 30. It goes up to a level 3. And the guideline, or the sentencing guideline range is now 12 to 30.
Check that, Mr. Allen.
I concur.
Very well then, Mr. Allen. Mr. Kerner, do you agree with that?
Yes.
Mr. Allen, if you're up to allocution.
Thank you. I think to echo, I look at my client's record and I've spoke to Mr. Maupin at length. He's a poster board of what substances, specifically alcohol, can do to someone's life. I reckon he's probably spent the majority of his adult life probably incarcerated in some form or fashion or dealing with his substance abuse issues. He's already in prison. I would ask the court to merely follow the guidelines and recommend some type of substance abuse while he's in the Department of Corrections.
Thank you, Mr. Allen. Mr. Kerner.
Thank you, Your Honor. It's amazing to me that someone has not been more seriously hurt by this defendant. I mean, I lost count of the number of drunk driving incidents that he's had. He's got assaultive behavior.
Listen closely to the prosecutor here. This stopped being about addiction alone and became about danger to the public. 8 drunk driving convictions. The court sees that as a ticking time bomb.
And he is in prison, but that's where he needs to be. I'd ask the court fashion a sentence that focuses on punishment and deterrence, Your Honor. Thank you.
Thank you. Mr. Maupin, this is your opportunity to address the court, sir. Is there anything you'd like to say?
Yes, Your Honor. Alcohol has ruined my life and that of my family and everybody that cares about me. We got taken away from my biological parents due to alcohol abuse and addiction and neglect, and I haven't been able to break the cycle. I mean, I've got a lot of good things to tell you, but it's all overshadowed by the negative stuff that I've never been in trouble in my life without alcohol being the key factor, Your Honor. My family and my children are, I can't imagine doing anything that would hurt them, and that's exactly what I've done, Your Honor. I've put them in a terrible spot, and now they're losing me, Your Honor. And
thank you, Mr. Maupin. The guidelines, well, they're advisory, but the court finds that they're scored accurately. The guidelines are a recommendation from the legislature. The court finds that the recommendation in this case is not proportional to the circumstances of this case. At the outset, the court notes that you were initially charged as a 4th offense habitual offender. In exchange for your guilty plea, the prosecution agreed to reduce your status to that of a second offense habitual offender. That agreement reduced your maximum possible prison exposure from a life offense to 7.5 years. The court is permitted to consider the nature of a plea bargain when fashioning a sentence. That's People v. Armstrong, 247 Mishap at page 426 of that 2001 case. And the guidelines consider each defendant's criminal history generally, but do not always account for certain patterns of conduct that might be relevant to sentencing. Here, Mr. Maupin, you stand convicted of operating while intoxicated, 3rd offense. Factually, though, this is your 8th such conviction overall, and your 5th felony conviction for drunk driving. That means OWI 3. The guidelines partially account for your extensive history of drunk driving. First, by enhancing this offense from a misdemeanor to a felony, which accounts for 2 prior OWIs. Second, by scoring the non-enhancing OWI convictions as misdemeanors in PRV 5. That consideration is inadequate because PRV 5 presumes that all scorable misdemeanors are equal. The court disagrees. Your record reflects an almost 30-year history of drunk driving, punctuated with intermittent bouts of incarceration, including terms in prison. That history weighs heavily on the court's mind in terms of public safety. The court doesn't want to overstate the point. Your criminal record does not consist exclusively of drunk driving convictions. While there are a number of convictions for other crimes, it is the drunk driving offenses that are most relevant to today's sentencing. Your presence in the community puts the community at risk. Another safety concern of this case is that you had a young child in the vehicle while you were driving with a blood alcohol level of 0.31. The custody and parenting time implications of that aren't before this court, but from a safety perspective, it's deeply troubling. The court can best meet the needs of public safety by fashioning a sentence of prolonged separation from society. Public safety is not the only concern at sentencing. The court must balance
A .31 blood alcohol level with a child in the car? That detail hit the courtroom hard. At this point, the judge is no longer focused on rehabilitation first. He's focused on protecting everyone else on the road.
other objectives as well. Nevertheless, what's far more compelling to the court is the litany of unsuccessful discharges and probation violations on your record. In fact, you committed this offense while on probation, so it seems unlikely that you would comply with any intermediate sanction that the court could or would fashion. The court considers rehabilitation to be an unlikely outcome for you. You've repeatedly been sent to the Michigan Department of Corrections, including a 2001 commitment for probation violations arising out of a drug driving case. In other words, you know better than most the criminal consequences of drunk driving, and you remain undeterred by those consequences. That leads the court to look towards incapacitation as a goal of sentencing. Based on the guidelines scored by the court, your recommended sentence falls into what we call a straddle cell. For the reasons already discussed, the court does not believe an intermediate sanction is proportional to the criminal behavior at issue. The ceiling of the guideline recommendation is 30 months. In your 2001 drunk driving case, Judge Ransom reduced you or sentenced you to the Michigan Department of Corrections for a minimum of 27 months, where your first felony drunk driving resulted in 27 months of incarceration. This court doesn't find it proportional to have your fourth felony drunk driving be punished by 30 months of incarceration. That's even before the court adds in more than 10 convictions for other offenses in the intervening decades. Having concluded that the straddle cells are an inadequate response to the facts of this case, the court looks to the presumptive prison cells of the same grid. The nearest such cell is E4, which reflects a one cell shift on the OV axis and produces a guideline minimum range of 14 months to 36 months. The court finds that range proportional to the circumstances of this case and you, Mr. Maupin, as the offender. The court would depart to impose its chosen sentence even if the guidelines were scored differently or if even only one factor were present. You do have some financial obligations. It includes the crime victim's assessment in the amount of $130, state costs of $68, court costs in the amount of $961. You will receive credit for 126 days. As to incarceration, Mr. Maupin, you will receive a minimum sentence of 36 months in the Michigan Department of Corrections, not to exceed 90 months. That will run concurrent to your present sentence.
And there's the upward departure, 36 to 90 months. The judge basically said the normal guideline range wasn't enough for someone with this history. That missed court date and years of repeat offenses came back all at once.
Mr. Twilliger, please include a directive to the Michigan Department of Corrections that Mr. Maupin must undergo a substance use evaluation per Mr. Allen's request, and he should follow the recommendations. Mr. Maupin, appellate guidelines are on the way. Please initial them, acknowledging that you've received them. If you'd like court-appointed counsel, you've got 42 days from today's date to make that request. Thank you.
Thank you.
Thank you, Your Honor.
Take care of yourself, Mr. Maupin.
Thank you.